Hello everyone and welcome to our EU court update for the agricultural and crop protection industry. The story is this: the legal and regulatory framework around pesticides in Europe is being under pressure on 5 different front lines at the same time. And it is not the legislator driving this. It is NGOs, Client Earth, Pan Europe and others, who have made again the EU courts their strategic instrument of choice. They are using litigation, transparency requests and Aarhus review procedures to reshape the rules of pesticides approvals, renewal and phase-out, case by case, judgment by judgment. And the courts increasingly are following them. So, if you are in the ag industry, you will want to pay attention. Let me walk you through what is happening and, more importantly, what it means for your business. The first front line is transparency. Until recently, when member states sat down in Brussels to vote on whether to renew or not to renew an active substance, those votes and the reasoning behind them stayed largely behind closed doors. That era can be over. In the Client Earth case, the General Court has now made clear that individual member state positions, justifications and votes in pesticide comitology must, as a rule, be disclosed. The Commission's standard arguments, external pressure, the need for mutual trust, the sensitivity of the process, were dismissed as too vague. There is still one narrow shield left: documents directly linked to pending and court proceedings. But for everything else, assume the default is now public. Word of caution: this is a general court judgment. It can still be set aside on appeal by the Court of Justice, and the Commission or intervening member states may well take that road. So, the principle is not yet carved in stone, but for planning purposes, you should assume it will hold. What does that mean for you? It means that every renewal file, every non-renewal file, every extension, the national vote splits will become visible. Reputationally and politically, this changes how member states behave, and it changes how you should engage with them. The second front line is the evidentiary bar for renewals. In the Pan Europe cypermethrin case, the Court of Justice has partially set aside the General Court's ruling and sent a very clear signal. Where EFSA has identified critical areas of concern, the Commission cannot wave them through by relying on reassurance from the rapporteur member state on theoretical mitigation assumptions or, and this is new, on repeated requests for confirmatory information on the same open point. That last move, the court now says expressly, is an abuse of procedure. The court also confirmed that risk mitigation measures must be realistic under actual farming conditions and that long-term toxicity must be assessed taking into account the interaction between the active substance and the other components of the products, not through generic safety data sheets only. And importantly, this is a final judgment of the Court of Justice. No further appeal is possible. The Commission must now reconsider Pan-European's internal review request, which may, in turn, lead to a reconsideration of cypermethrin renewal itself. For industry, the message is simple. Close your data gaps upfront. The era of fixing things later through confirmatory data might come to an end. The third front line is sustainable finance and the way it is starting to reach into the ag value chain. In the Robin Wood case, the General Court dismissed an NGO challenge against the inclusion of forest biomass bioenergy in the EU taxonomy. On the surface, that looks like a win for the industry, but read the small print. The court signaled that the do not significant harm criterion, the so-called DNSH test, which under the taxonomy requires that an economic activity, while contributing to one environmental objective, does not seriously harm any of the others, is implicitly incompatible with excessive pesticide use, at least insofar as it requires biodiversity-friendly practices. That is an interpretive marker, not a hard exclusion, but it is the direction of travel for any future feedstock, including crop-based biofoods. This too is a general court judgment, and appeal to the Court of Justice remains possible. Given the strategic stakes, taxonomy, the Renewable Energy Directive, Aarhus access, an appeal by the NGOs is plausible. What it means for you? Expect biofuel off-takers driven by their own reporting obligations under the Sustainable Finance Disclosure Regulation and the Corporate Sustainability Reporting Directive to push greenhouse gas reductions, biodiversity and integrated pest management requirements down the chain to seed and crop protection suppliers. The pressure will come through contracts, not through regulation in this case. The fourth front line is about the return of innovation, supplementary protection certificates, or SPCs. These are in the EU patent term extensions of up to 5 years that compensate for the time lost to regulatory approval. For an innovative active substance, an SPC can be the difference between a good investment and a great one. In the 𝗘𝗨 case on the pharma side, Advocate General Emilu has just told the Court of Justice, a substance classified as an excipient can not be an active ingredient for SPC purposes. Strict, formal, regulatory classification driven. The good news for the ag industry, the Advocate General expressly preserved the more generous plant protection line, the so-called Bayer crop science case law, under which a safener can qualify for an SPC if it has a plant protection action of its own. But, and this is the strategic point, the Advocate General has voiced certain reservations. The door has been left ajar. The farmer side is being tightened, and over time the pressure may spill over. So the opportunity, and it is a real one, is now. If you have safeners, novel adjuvants or combination products in the pipeline, secure your SPC files while the favorable case law stands, and make sure your authorization dossier itself documents the independent phytopharmaceutical action of the substance. That is the trigger. That is your insurance. And the fifth front line, the newest one, is grace periods. When an active substance is not renewed, industry has traditionally relied on a transitional period of up to 18 months to manage stocks, supply chain, and the transition for growers. That predictability is now under attack. In a new case before the General Court concerning the non-renewal of flufenazet, two NGOs, Pan-Europe and Deutsche Umwelthilfe, are arguing that where non-renewal is based on health or environmental grounds, the 8-month maximum should not apply at all. They want shorter grace periods or none. precisely for those substances where industry needs transition time the most. The case is pending, but the signal is already clear. Do not assume the full 18 months will survive judicial scrutiny. Build shorter period contingency scenarios into your commercial planning. Document during the comitology phase the practical necessity of transition periods, stock levels, agronomic alternatives, supply chain lead times. And where the commercial stakes are significant, consider intervening in this case on the side of the Commission. So, overall, 5 front lines: transparency, renewals, sustainable finance for biofuels, SPCs, and grace periods. The common thread is unmistakable: a steady tightening of the regulatory and procedural environment around pesticides in Europe, driven by NGO litigation and an EU judiciary that is increasingly receptive to it. But, and this is where the story turns, tightening also means repositioning. Every one of these developments cuts both ways. Where the regulatory environment becomes more demanding, it also rewards those who are preparing. Where established positions come under pressure, new openings emerge for those who move early. And where transparency increases, the well-prepared player gains just as much as the critical observer. The industry that wins the next 5 years is the one that reads these signals early and adjusts regulatory, IPO and commercial planning accordingly. If you would like a written briefing on any of these 5 matters or a tailored assessment what they mean for your portfolio, please get in touch. The contact details are below. Thank you for watching and see you the next time.